Now to the distinguished representative of Sri Lanka.
Madam Chair, may I first of all thank the Special Rapporteur for her very comprehensive report on the immunity of state officials from foreign criminal jurisdiction. Madam Chair, the topic of functional immunity of state officials with respect to international crimes committed in an official capacity remains a matter of great argument. In 2017, the ILC temporarily adopted a draft article stating that functional immunity from the exercise of foreign criminal jurisdiction shall not apply in respect of the crimes of genocide, crimes against humanity, war crimes, the crime of apartheid, torture and enforced disappearances as set out in the ILC's report at its 69th session. Interestingly, one member of the Commission was heard to observe, quote, that debate proved to be one of the most contentious within the Commission in years. At the same time, in the 6th Committee of the UNGA, 24 states expressed general support for the draft article, whilst 18 states expressed general concern. The question was asked, therefore, as to where states really stand on this matter. The academics seem to suggest that the relationship between functional immunity of state actors and the lawful combatant immunity of the military has not received adequate consideration. It may be noted that the ILC Special Rapporteur Roman Anatolovic Kolodkin, in his second report on the immunity of state officials at its 62nd session, had taken the view that the issue of criminal prosecution and immunity of military personnel for crimes perpetrated during military conflict in the territory of a state exercising jurisdiction would seem to be governed primarily by humanitarian law and should not be considered within the framework of the topic of official immunity. It is reported that at least one member of the ILC was of the view that the ILC considers the relationship between official immunity and combatant immunity, and went on to say that it was in the field of international humanitarian law that the issue of exceptions on the ground of immunity had been discussed and analyzed to a large extent. The result was that the Special Rapporteur's view prevailed. The discussion of the topic did not continue and was dropped, resulting in the draft article remaining pro forma without prejudice to the immunity of criminal jurisdiction employed under special rules of international law, in particular to persons connected with diplomatic missions, consular posts, special missions, international organizations, and military forces of a state. So the resultant position is that when one looks at the concept of immunity and responsibility, academics are of the view that while the laws of war bound both states and individuals, breaches of these rules committed under the order or sanction of government for all purposes were acts of state, not of individuals concerned, and as such gave rise to the responsibility of the state alone. It would appear, Madam Chair, that as the International Court of Justice explained, immunity is one thing and responsibility another. The arrest warrant of the 11th of April 2000 in the case of the Democratic Republic of Congo versus Belgium clearly brought out the rationale that immunity from criminal jurisdiction and individual criminal responsibility are two different concepts. It went on to say that jurisdictional immunity is procedural in nature and criminal responsibility is a question of substantive law. The resultant position is that this separation of procedure from substance permits us to accept the position that state agents are now responsible for international crimes committed in an official capacity, although they may remain immune from prosecution in foreign courts. It would appear that international law cannot criminalize and immunize official acts at the same time. If official acts are immune from prosecution, then international law does not assign a sanction for such acts. And if there is no sanction attached, then there is no crime and no responsibility. Madam Chair, it would appear that any waiver of procedural immunity establishes criminality of the act and the responsibility of the actor. It may be observed that the ILC, in its publication of the draft codes of crime against peace and security of mankind in 1996, went on to observe, quote, the absence of any procedural immunity with respect to prosecution and punishment in appropriate judicial proceedings is an essential corollary of the absence of any substantive immunity or defense. It would be paradoxical, I say, to prevent an individual of invoking his official position to avoid responsibility for a crime only to permit him to invoke the same consideration to avoid the consequences of his responsibility. It has also been observed that immunity and impunity are not the same and should therefore not be conflated. It must be appreciated that we are now in a position to consider the strength in the argument that responsibility and immunity are logically incompatible. It must be borne in mind that sanctions may be legally authorized but difficult to impose. A variety of legal obstacles to lawful punishment may arise in the course of a criminal prosecution without addressing the underlying act of criminality for a multitude of reasons. It is also widely accepted that high government officials enjoy personal immunity from criminal jurisdiction, including international crimes. It is a fact that the practical effect of immunity from arrest and other coercive measures will be such that high officials will never appear before foreign courts who are empowered to impose individual criminal liability. It would therefore, on a cursory consideration of the legal position, appear that it is open to debate that substantive criminal responsibility and procedural immunity are logically independent. The debate appears to have no end in sight, and it is believed will go on for some time. Let me now turn to something more serene, the sea, to say a word about sea level. You may agree with me that sea level rising would disproportionately affect the territorial sovereignty of territorial states, especially the small island developing states. The law of the sea, Madam President, gives every state the right to a claim to territorial sovereignty over its territorial sea, up to 12 nautical miles from its baseline. While the rise in sea level has become a growing concern for some states, it must be accepted that SIDS stands on the front line for the reason that the impact of a rising sea level results in the displacement of their people to undermining their food, water security in the foreseeable future. Now, we must appreciate that a fixed baseline approach in the fixing or on the question of where the line is requires states to permanently delineate the outer limit of their maritime jurisdiction limits by fixing their baseline, which are to remain effective irrespective of the submersion of coastal areas due to the rising sea level. Now, although the law of the sea says that the maritime boundaries shall not shift, it does not exclude the possibility of resourcing to either of the two approaches. Perhaps it is time the ILC should examine whether a treaty can be modified by mutual consent or the subsequent practice of all state parties who are party to it. It is possible, I say, for the ILC to consider whether UNCLOS can be modified or whether it cannot be. I wouldn't want to venture an answer to that question except to say that state practice of SIDS is to prefer a fixed baseline approach. The reasoning behind this is that the rise in sea level and the subsequent loss in exclusive economic zones of developed states do not substantially hamper their freedom of navigation and entitlement in the high seas. There is, I say, a possibility for the ILC to develop the rules of customary international law to modify the treaty with respect to the approach preferred in delimiting maritime boundaries. Finally, the treaty proceedings, as we see, UNCLOS did not provide for EEZs, but regarded everything apart from territorial seas as high seas. Then every country was given a 200-mile economic zone from their baseline. It is of interest, I say, to note that although a state practice violated the practice of state provision and was resisted by developed states and the ILC until about 1970, the EEZ finally came to be accepted by states by virtue of the new customary norm. Therefore, changes in international law have been taken into consideration in the interpretation of treaties, and the ICJ has noted that newly developed laws of environmental law are relevant to international treaties. I thank you, Madam Chair.
I thank the distinguished permanent representative of Sri Lanka. I now